So many more questions. Good morning, ladies and gentlemen. This is also Oil and Gas Commission for July the 23rd. We're in El Dorado, Arkansas. And I will turn it over to Larry Bangle, the director.
Thank you, Chairman. Two announcements quickly. There's a lot of folks in the room. That means a lot of phones in the room, so if you silence your phones so they don't have a lot of ringing going on. Disrupt the court reporter in our proceedings. Number two, I'd like to welcome Rachel Natton from the governor's office here today. Rachel over here. So she's visiting and we'll welcome her at our proceedings. That's all I have.
All right, Mr. Director, you turn it over to me. Yep. Good morning, commissioners. Morning, members of the public. I'll note for the record that all the commissioners are present either in person or via Zoom, except for Commissioner Liner. And I would request a motion on Commissioner Liner's absence, please.
Take the motion.
Second. Commissioner Wilford has made a motion. Commissioner Weiser has seconded. Show of hands. Motion passes. First item I've got on the agenda in terms of the docket, docket number 033-2024-06, Merit Energy Company, LLC. The attorney is Mr. Jim Rankin. Subject is extension of temporary abandonment status. Location is Section 5, Township 7 North, Range 16 West. County is Conway, the field B43 well spacing area. Mr. Rankin, you are recognized, sir. How are you this morning?
Thank you, Judge Bolton. Doing very well. Good morning, commissioners. This is an application to extend the temporary abandonment status for the Voss 7-16-1-5H well. The list of pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is a fluid level test. I have handed those out, and they should have been at your stations when you got there this morning. The Exhibit C is a proof of publication. Exhibit D is the affidavit of notice. Originals of C and D have been provided to counsel for the commission. The docket numbers on these fluid level tests appear up here in the top left corner. And with that, I move the introduction of the exhibits.
Before I grant your motion, Mr. Rankin, any recusals on this matter, commissioners? But for the record, there were none. Your motion is granted. Those exhibits are now made part of the record.
Thank you. This is the Voss number 1 well. In this unit, there were previously 5 wells. The Voss 3 and 4 were plugged in 2019. The Boss 2 and 5 were plugged in 2021. Merritt would like to extend the TA status of this Boss well as a candidate for a saltwater injection well. It's located about 2.3 miles southwest of the E-Rowlett 1-SWD well. It serves as a potential replacement for a saltwater disposal well on the west side of their acreage. The logs and seismic of the Boss number 1, along with the other wells in the nearby area, have been analyzed to identify a shallow injection zone within the Boss number 1 that appears to have a viability as a safe and economic injection zone. We have been before you a couple times in the last year on behalf of Merritt, dealing with their saltwater issues up there. It should be noted that this particular well is outside of the moratorium zone. That's why it's important to Merritt to keep it as a possible alternative. With that, we'd like to extend the TA status for another 3 years.
Thank you, Mr. Rankin. Does that conclude your presentation for the moment?
Yes.
Commissioners, any questions?
Do you have an agreement on the surface side?
Not right now. There were 2 well pads in this unit. The westernmost well pad has been turned back to the owner. Aerial photographs, he's got hay and tractors on it. He's using it. This one, we don't have a surface use agreement yet. We'd certainly do that before we take any steps to convert it.
Any other questions from the
How
commission?
far outside the moratorium?
I don't know how far outside. I just know that it is outside.
Any other questions from the commission? Anyone in the audience wish to speak to this matter? If not, I'll call the evidentiary record to a close. Commissioners, this matter is ripe for adjudication. Is there a motion from the commission? Second. Commissioner Wolford has made a motion to approve. Commissioner Weiser has seconded. All in favor, show of hands. Motion passes, 8 votes. Next item on the docket number 034, 2024-06. Again, Merritt Energy Company LLC, Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status, location section 6, township 7 north, range 13 west. County is Faulkner, field D43, well spacing area. Mr. Rankin, you are again recognized. Before you get into it, any recusals on this matter? Up to the record, there are none. Please proceed, Mr. Rankin.
Thank you, Judge Moulton. The list of pre-filed exhibits appear on page 2 of this application. They are Exhibit A, the list of parties receiving notice. Exhibit C, the proof of publication, and Exhibit D, the affidavit of notice. The originals of C and D have been provided to counsel for the commission. Exhibit B is the fluid level test. I handed out another fluid level test for this well. This well is a candidate for a workover. The Hammett number 2 is in need of a permanent compressor for gas lift to ensure consistent production. Total job cost to move the compressor over and get the well producing is estimated to be $10,000, and a gas price of $3.70 is required to make it economic due to higher operating costs and including fluid hauling and permanent compression. Shut-in payments have been made. There is a lease on the well site. It would move the extension of the TA status for an additional 3 years.
Thank you, Mr. Rankin. Questions from the commission? Anyone in the audience wish to speak to this matter? For the record, there was no response. Mr. Rankin, anything else you need to add?
Do not.
Not, I'll call the evidentiary part of the record to a close on this matter based on Mr. Rankin's presentation and the extensions. The records were none. This matter is ready for adjudication. Is there a motion from the commission? Chair Langley has moved to approve. Is there a second? Phillips has seconded.
No.
Show. Oh, sorry. I'm gonna keep doing that to you, Commissioner. I don't know why. That's all right. Like that. Commissioner Lawson is seconded. Show of hands. All right, motion passes, 8 votes to none. Thank you.
Thank you, Judge.
Next item, docket number 038, 2024-06, has been continued. So that means the next item on the agenda is docket number 040, 2024-07. Albemarle Corporation, Mr. Daly is the attorney of record. Subject matter is an order confirming that pilot plant operation will not constitute quote profitable extraction end quote of lithium chloride. Location is multiples. County is Columbia. Field is Albemarle's West Field, voluntary. I recognize Mr. Daly. Any recusals on this docket from the commission? I will note for the record there were none. David, you are recognized, sir.
Thank you. The applicant's documentary evidence is summarized and tabulated on its Exhibit E. I will tell you that I have given commission staff the proof of publication and the affidavit of mailing this morning. We move the introduction of the Exhibit E and the application and the exhibits tabulated thereon into evidence at this time.
Motion is granted. Those exhibits are part of the record. Mr. Daly, I also have another document here dated, the letter from you dated July 19th, 2024. Is this letter part of what I just introduced?
Is that the letter that amended the application?
It is.
I should have told you, Mr. Moulton, that the application has been, an amendment to the application was tendered by that letter, and we moved that the substituted or the amended application be substituted for the original.
All right, thank you, Mr. Daly. That motion is granted. Tony, you're recognized as well. I have a letter dated July 18th, 2024 from you. I assume you want to move the admission of this letter as well.
I do, thank you.
Motion is granted. Do you want to read this letter, Mr. Honey? We'll get that out somewhere down the line. Mr. Daly, I'm going to turn back to you.
All right, I have one witness, Mr. Steve Card. I ask that he be sworn.
Sir, would you be so kind as to raise your right hand? Do you swear or affirm the testimony about to give in this hearing is going to be the truth?
I do.
Thank you, sir. Please proceed, Mr. Daly.
State your name, please, sir,
Steve Card.
and how are you employed?
I'm employed by Albemarle Corporation.
In what capacity?
I am the Community Affairs and Land Director for Magnolia Operations.
Are you familiar with the request of Albemarle in the application before the commission?
I am.
Did you, in fact, help prepare that application?
I did.
Does Albemarle intend to sell any of the lithium chloride or any derivatives thereof that might be extracted by this pilot plant?
No, sir. This is not for commercialization. This is, we're not going to sell any lithium extracted from this process.
What is Albemarle's position with regard to the data developed by the pilot plant?
First of all, we voluntarily filed this pilot plant permit to provide transparency to the purpose of this plant, which is research and technology based.
What are you going to do if permitted? What are you going to do with the data, the information that you obtained regarding the amount of lithium chloride extracted and so forth?
Okay, so that data is going to be used internally for our development of a process, and any product will be not sold. It'll be, most of the lithium will be returned back in the tail brine. Then we'll have records of all the material that is
And is it your wish that those records be retained in Magnolia but available for inspection by the commissioner at all times?
Yes, sir.
At all times. What problems do you foresee might occur if some of the data mentioned in Mr. Honey's letter becomes part of the public record?
Well, first of all, our operations in the Smackover, which we operate in, learned a great deal since Mr. Honey filed his motion in 2018. It's a more competitive landscape now exists in southern Arkansas. And due to that competition, the Smackover and confidential and proprietary nature of some of those records, Albemarle maintains those records, make them available to commission only and not making public this time. Albemarle has to protect their technology, and that's what we propose.
And is there a particular concern about vendors and lists of vendors and potential customers that you might send samples to as to the industrial security aspect of that?
Absolutely. So we have existing customers now, vendors and suppliers, and we have non-competes with some of them. We have, some of those do not want their names mentioned in public places.
And of course, anything that you file with the commission is immediately a public record, and there's
That's
nothing that you or the commission can do about it.
That's correct.
So it is, in short, your position that you'll maintain all these records and they'll be available for commission inspection. But you don't want to allow them to be public records where people who have no business with them can do bad things with them.
That's correct.
And I would add to that, commissioners, that this is not even a unit formed by order of the commission, because Albemarle was fortunate enough to be able to put it together voluntarily with pooling clauses in their various leases. It is totally voluntarily that they make this request, simply because they seek a verification that if they don't sell any lithium products, then lithium is not being commercially extracted, and therefore it's not time to trigger a royalty responsibility. I understand Mr. Honey's position, but respectfully disagree with the part which has to do with filing with the commission and putting it on a website.
All right, thank you, Mr. Daly. Honey, any questions for this witness?
I would just ask for an opportunity before we close the record to make a couple of comments, but I have no questions for this witness.
Mr. Perkins, I'm not going to leave you out. You're sitting there. Any questions for this witness?
I have no questions. I'm perfectly happy with this application.
Mr. Daly, you rested this?
Yes, sir, we do.
All right, thank you, sir. Mr. Honey?
Just a couple comments. As I stated in the application back in 2018, when Standard Lithium was granted authority to operate a pilot plant, the commission imposed certain reporting requirements, regarding volumes and concentrations and just some scientific data. Mr. Daly brought up identities of customers. As I read the requirements, there is no requirement of identifying any customers, so I don't think that's an issue. I note that the reporting requirement is something that came out in the course of the hearing at the request of the commissioners. It was not requested in the original application. The applicants did not ask for it. It was something that the commission just, in the course of the hearing and the questioning of witnesses, came up with. But I do think it does serve a purpose in the sense that this commission is responsible for verifying and regulating, brine and the extraction of materials from brine and the payment of royalties on the brine, on lithium. So there is a valid basis for it. I also note that retaining the records and making them available for inspection by the commission, the commission is going to have an obligation and a responsibility to inspect those records. When it does, that information is going to become subject to the Freedom of Information Act. So one way or another, the information is going to become publicly available. It's just a question of how it happens. And then lastly, I'll point out that there is some value in consistency. When the pilot plan has been in front of the commission previously, the commission has imposed these requirements. As I said, I think it's important for the commission to follow its own precedent, and I think that applies in this instance.
All right, thank you, Mr. Hunt. Daily, any rebuttal?
Very briefly, the commission has one role in a pilot plant, if you will, a scientific experiment. And that is to be comfortable that it does not result in commercial profitable, is what the statute says, profitable extraction. This is a company that's been in business in Columbia County, Arkansas, extracting bromine since I was a child. And that was a long time ago. And I think it has certainly deserves the trust and respect of state agencies and the community that it's not going to cheat. And it isn't going to sell any lithium until it tells you that it is, and until the royalty paradigm is solved. Everything else is things that the world may be curious about, but it gets over into the area of industrial secrets, and that's what the problem is about. And you know, honestly, Albemarle and I certainly don't object relieving Standard Lithium of some of those duties at this point in time. We're years down the road, and I think the world knows what pilot plants do. That's all.
Thank you, Mr. Daly. Gentlemen, does that conclude your presentations for both of you?
Yes.
Thank you. Commissioners, any questions?
Mr. Daly, would you agree that if the commission has access to the data, is it subject to 40? So if this information that's going to be kept in their El Dorado office, if the commission has access, is it a FOIA accessible?
I don't know that the raw data becomes FOIA accessible. I think the commission's conclusions after inspection are certainly FOIA. But I'm not a FOIA expert. That's my impression.
When on your direct testimony from Mr. Carr, you said the records will be retained in El Dorado. Where in El Dorado?
I know I absolutely misspoke. At the plant in Magnolia. Certainly at the site.
Any other commissioners?
Clarification.
I'm sorry.
Sorry.
Commissioner Lesson.
So we have a voluntary unit that's already in existence. We require across the state, whether it's oil and gas or anything else, to publish certain public information within a certain period of time at minimum. What about just the parts per million and that kind of thing? This is sort of public information. I don't think anybody's asking for customer lists or those kind of things, but is there an objection to just the quantity of, I think there's a public information benefit to know how much the quantity of lithium concentration in a particular area is, just for the broad Smackover trend? Is there an objection to disclosing that?
Well, Commissioner Lawson, I think generally yes, because of the competitive nature of parts per million and how they change in the field from side to side. So
But you already have a voluntary unit that you control, so how is that gonna be a competitive disadvantage to you?
Oh, it's the IP on the DLE process. That's what I'm calling competitive. It's not the leaseholder information. That can be construed when you have your concentration and more data, that actually a good engineer from another company could actually use that data to back calculate what you're actually working on, what chemical you're identifying in your process.
You're talking about your DLE process?
Yes, sir. And the feed is part of that.
If you know the concentrations in the water and you know the result of the DLE, you're a long way to reverse engineering the DLE process.
Right, but there's a lot of different DLE processes out there, my understanding. Anyway, there's at least multiple companies around the world claim to have a DLE process is proprietary, unique, and all those kind of things. Anyway, my concern was just, since it's probably subject to FOIA anyway, as Mr. Honey said, why not just release what the part per billion are, and that's it, not getting your technology, DLE, and all that. I agree that's confidential and proprietary information, the process that you use to extract it. I'm not so sure you can accurately back calculate that, frankly. But it's an evolving technology, this DLE, direct lithium extraction. So, thank you.
Any other commissioners?
What? Yes. Per Mr. Holmes' letter, is 2A, the total volume to tail grind run through the pilot plant, is that projection?
No, sir.
Commissioner Smith, I'm not trying to leave you out. If you've got a question, raise your hand so I get my attention. Any other commissioners? Mr. Chesterton, does staff have any input on this matter one way or the other, and particularly as it relates to the upper lot issue?
I would just say that under FOIA, there's two questions here in my opinion. It's first, FOIA, we're subject to production requirements if something is in our possession. Just going to inspect records doesn't mean that documentation is in our possession, subject to production or any request of that time. So it sounds like with what they're doing, we don't have anything in our possession to provide if we got an immediate FOIA request, unless we went and documented something during the inspection. At that point, any documentation we had would be publicly available. But there's a side issue to that as well. The second point is it subject to production under any exception for confidential or proprietary information? That's something we would have to do a little bit more legal research on to see if we got a FOIA request and they indicated that this was something that was exempt under the statutory exemption. Would we have provided it at that time? That could lead to other litigation going on with the circuit court, even at that point, if there's a disagreement on that. So I think you have two issues. Is it in our possession to make it publicly available through disclosure? And is it something that's exempt? I can't tell you if that's the situation right now based on what I've heard.
Thank you, sir.
Steve, how long do you want to hold it quiet or silent or?
Mr. Lane, I'm not sure what the question, hold what?
The information?
Oh, we'll keep the information for the life of the project.
Gentlemen, based on Mr. Pinkerton's presentation, any response from either Mr. Daly?
I guess my comment would be, I understand Mr. Pilkington's comment about being in the possession of the commission, but I don't see how the commission is going to inspect those records without making some notation of the data they use to verify that yeah, they looked at it. Yes, they verified that, the numbers, there's no royalties owed, that everything is in compliance. For the commission staff to conduct an inspection and then say, yeah, I figured it out, it's all good. Well, how? Where's your data? What led you to that conclusion? Well, just trust me, it's all in my head. I don't see that as being realistic. And once the commission staff makes any kind of a note or record or a calculation based on the data, it's public.
Thank you, Mr. Hubbard.
I would respond, if I may, that that's an exercise in forecasting the future, that it should not be taken as an absolute. You don't know what the commission's conclusion document might say. It could probably reach appropriate conclusions without revealing things that we don't need to have revealed. Certainly, if you pick up the raw information and house it in North Little Rock, Arkansas, or El Dorado, Arkansas, in a commission office, it's subject to FOIA instantly.
Thank you, Mr. Daly. Commissioners, I want to make absolutely certain you have both Mr. Daly's amended application as well as Mr. Honey's letter in front of you. I think it's passed out to everybody. All right, any other questions for the commission for any of these four gentlemen?
I'd just like to say, this is new territory for the commission. It isn't the first time we've been here. With stuff in North Arkansas especially. But as we learn, as we go and we grow in this field of industry, we get a better feel for what, is happening and what needs to happen. And I understand, commission ain't perfect. We make the best decisions we can, but going back to Mr. Haynes' statement, we've done this in the past and we got to do it this way again. As we evolve in this, and we learn more data and information, I think we got to be open-minded that, maybe we do something a little different, to protect. The biggest thing is, we need these projects in the state of Arkansas. I don't want to lose sight of that.
All right, thank you, Commissioner Phillips. Any other questions from the commission? Anything else you want to add to your presentations?
Not from us.
Anyone in the audience wish to speak to this matter? If I would look for the record, there was no response from the audience. With that, I'll call the evidentiary part of the record to a close. This matter is ready for adjudication. Commissioners, do you have a motion?
Make the motion to approve that applied for your amended application.
Commissioner Thomas has made a motion to approve the amended application.
You want to add that to A? How do we need to word that? Just as an addition to their application. We need to approve the application as applied for with the exception of including 2A. That's Mr. Holmes. That work?
Motion by Commissioner Thomas. Commissioner Phillips, would you second that motion? All in favor, show of hands. I have 7 votes in favor. 8. Oh, I'm sorry, 8 votes. 8 votes.
I'm a no.
Oh, you're a no? Yeah. That's what I thought. Commissioner Wilford is a no, 7 in favor with 1 against. Motion passes. Thank you, gentlemen. Commissioner Wilford. Next item on the agenda is docket number 041-2024-07. Metro Technologies Incorporated. Mr. Daly is the attorney of record. Subject matter is amendment of order number 022-1-2023-04. Location 6,138 acres in Lafayette and Columbia counties. County, of course, is Lafayette and Columbia, the Evergreen Brine Unit. How did I pronounce that, Lafayette, Mr. Perkins?
That's correct. Lafayette. That's not Lafayette.
Any reports on this matter?
Have a comment, just real quick. Just for total transparency and clarity, as I think many people in this room already know, I was previously a minority investor in a company called Galvanic, which owned the saltworks. We sold it over a year ago, before long before I was on the commission, to ExxonMobil. And just want to make that apparent. I thought, should I recuse on this or should I abstain? Have no interest in the company whatsoever. We sold 100% of it over a year ago in January 2023. So is there any objection to me addressing this matter by anybody in the room?
I don't know for the record, Commissioner Lawson, there's no objection, but even if there were, if the way abstentions or recusals work, it's within the conscience of the commissioner. If you think you are biased in some form or fashion or have a conflict, that's up to you to internally decide. Of course, it's pretty kind of you to solicit information from the audience as well.
You know, I've lived my life doing always the right thing, and I want to do the right thing in this case, and full transparency helps you doing that, and so that's the reason I want to make that comment.
Oh, absolutely. No problem with this. Yeah, no problem with the topic.
The applicant certainly does not request you to recuse.
Okay.
All right. So no recusals on this matter, Mr. Daly, I'm sorry.
Thank you. The applicant's documentary evidence consists of a mere 4 exhibits, the last of which is the list of exhibits. We move the introduction of those exhibits into evidence as tabulated on Exhibit D and request that Mr. Henry Langley, our only witness, be sworn.
The motion is granted. Those exhibits are part of the record. Sir, would you be so kind as to raise your right hand? You swear from the testimony you're about to give in this hearing is going to be the truth. Thank you, sir. Please proceed, Mr. Daly.
Henry, please state your name.
Henry Landry.
You need to lean into the mic a little bit, Henry.
Yeah, Henry Landry.
There you go. And how are you employed, Henry?
I'm employed by Tetra Technologies.
In what capacity?
I am a vice president in the chemicals division.
And what are your duties with respect to the Evergreen Brine unit?
Yes, I'm overseeing construction of the unit such that future operations will report into me. So my vested interest is to make sure this is an operable site.
I'm sure that you're familiar with the application where we request the amendment of certain language which could be read to require the actual, at least preparation, if not drilling of wells before the unit is ready for wells. Is that true?
That is true.
Would you explain to the commissioners the process that begins with the creation of infrastructure and the sequence, the ideal sequence of where drilling the wells falls in that process?
Sure. Yeah. The reason behind our request is really to optimize the logical sequence of execution for the project. It's best for a whole host of reasons that the wells are drilled and completed and not sat idle for a long period of time, up to a couple of years prior to brine processing. However, this request does not elongate the period of time between now and the intended brine processing date. That is somewhat fixed by our ability to construct the facility, obtain long lead items, and build. And many of those activities have already commenced.
Just very briefly explain to the commissioners the major things that have already occurred or are physically ongoing today.
Sure. In terms of pure spend, as stated in the application, we have invested approximately $50 million since we began work and through the period ending September of 2024. We've drilled 2 test wells in the area and done extensive testing and are exploring plans for a 3rd well in the area. I think of reasonable importance is we've acquired a 126-acre site in Lafayette County where we intend to build the brine processing plant. As it would happen, clearing and grubbing activities have started on that site this very week. We visited yesterday to witness some of that activity. We performed an aquifer study with professional geologists to ensure that our extraction of water is not harmful to local residents in the aquifer. We've worked with the ADEQ as well as the Army Corps of Engineers to perform studies on the wetlands and to acquire the necessary permits to begin the activities that I mentioned have already started. We've entered into an agreement with the Southwest Arkansas Electric Cooperative, which is a very sizable agreement. We believe perhaps one of the largest, if not the largest, singular infrastructure upgrade to the electrical grid in that area in many, many years. And engineering efforts continue. The FEED engineering stage is well underway in Houston and is slated for completion toward the end of October of this year.
And in all of this creation of infrastructure and that'll ultimately lead to production and injection and processing of brine, where is the logical place to put in sequence the actual drilling of the wells?
Yeah, so I'm at liberty to disclose that our intended brine processing date is approximately first quarter of 2027. And it's our desire to time the well completion such that the wells are not idle for a number of years prior to that. Well drilling activity is currently scheduled for commencement midpoint of 2025 if the commission so approves, and completing early in 2026.
And I understand that you're going to borrow some technology from the Fayetteville Shale and use a walking rig that'll drill all of those wells without ever being released.
Yeah, so that's another, I think, viable part of the request is that our hope is to do the entire well field in a singular drilling campaign, moving the well rig from one hole to the next and completing all of the supply wells and the injection wells in a singular campaign, not mobilizing and demobilizing the drilling equipment into the region and out of the region numerous times.
And you're going to get 10 wells with only 3 surface locations?
That's correct. And 2 of those locations have already been secured. Engineering, the surveying, construction outlay lines have already been completed for those 2 well pads. And we believe there's an environmental stewardship component to that as well as efficiency.
Questions for Mr. Langley?
Commissioners, any questions?
I called you Langley. Landry. He's Langley. You're Landry.
Close enough.
There were several provisions in the unit order that were amending, you're just amending the time frame. There was other provisions with respect to well location, with respect to overlay or overlapping Mission Creeks. This will not affect any of that.
This does not affect any of the development plan whatsoever. It's simply a timeline shift of the well drilling activity and not a timeline shift of the project itself.
And the well locations provided for in that particular order, still you're using the same location.
At current, yes. Yes.
Any other questions from the commission? I do have a card that has been filled out for this docket. Remy Rousseau, representing Saltworks. So would you be so kind as to identify yourself for the record, please?
Yes, good morning, Commissioners. My name is Remy Loazo. I am the Lithium Area Manager for ExxonMobil, the owner of our affiliate Saltworks, and I'm here representing that today. I'd just like to make a quick statement as you all know or are aware, Saltworks is a participating interest inside of the Evergreen unit, and we'd like to offer our support and recognition of the proposal that Tetra has here today for their operations. That's it.
Any rebuttal to that?
Absolutely not. That would be tough to rebut.
I gotta ask. Commissioners, any questions? Mr. Daly, the rest?
Nothing further.
All right, thank you, sir. At this point in time, I call the evidentiary part of the record to a close. This matter is ready for adjudication. Commissioners, is there a motion? Mr. Weiser has moved to approve. Chair Langley has seconded. All in favor, show of hands. Motion passes 8 votes. Thank you, Mr. Daly.
Thank you.
Thanks, Commissioner.
Oh, okay. All right, next item on the agenda, docket number 042-2024-07. Flywheel Energy Production LLC, Ms. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location is section 29, township 8 north, range 14 west. County is Conway, the 42 Los Basin area. Any cases on this matter, commissioners? There are none. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are shown on page 2 of the application. They include Exhibit A, list of the parties receiving notice. B is the fluid level test of June 12, 2024. C is the proof of publication. D is the affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. We would ask that those exhibits be admitted to the record.
Perkins, your motion is granted. The exhibits are made part of the record.
This particular well, the Criswell 814-12-29H, is a horizontal well that was completed in the Fayetteville Shale Formation. The applicant needs to reset gas lift, reinstall a plunger, swab it back, and it may need a tubing perforation. They won't know until they get into it. The applicant anticipates that this well can be returned to profitable production and intends to do so. The estimated break-even price for this well is $3.78. Flywheel, of course, agrees to the other commission-imposed restrictions, and we would ask that it be allowed to retain this well until it can be worked over and returned to production.
All right, thank you, Mr. Perkins. Commissioners, any questions for Mr. Perkins? For the record, there are none. Mr. Perkins, does that conclude your presentation?
That concludes my presentation.
Thank you very much. At this point in time, I call the evidentiary part of the record to a close. This matter is ready for adjudication. Commissioners, do you have a motion? Move we approve. Quicker, Commissioner Westfall or Commissioner Larson?
Second.
Motion made by Commissioner Larson to approve, seconded by Commissioner Westfall. All in favor, show of hands. Motion passed. Commissioner Smith, did you vote on that one? Thank you, sir. Perkins, you are up next, which is why you haven't abandoned your chair. Next item is document 043-2024-07. Applicant is Van Buren Energy Production LLC. Mr. Perkins is the attorney of record. Subject to the extension of temporary abandonment status, location section 15, sections 10 north and 14 west. County of Van Buren, Field of 42 Los Basin area. Any excuses on this matter, commissioners? For the record, there were none. Questions were recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2 of the application. They include Exhibit A, list of parties receiving notice. B is a fluid level test of July 19, 2023. C is a proof of publication, and D is an affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. Would move that those exhibits be admitted.
Granted, those exhibits are not part of the record.
And this is another typical temporary abandonment extension application. This particular well, the Allen 1014 2-15H well, doesn't need very much treatment. It just doesn't produce very much gas. It needs a foamer treatment and a mobile compressor. The estimated break-even price is $1.20. And of course, Van Buren would agree to the commission imposed restrictions. Van Buren would like to retain this well in order to return it to production.
Thank you, Mr. Perkins. Commissioners, any questions?
$1.20, that's impressive.
I'm sorry? Yeah.
$1.20, that's impressive.
And it produces about 40 MCF a day. So, you know, yes, it doesn't cost very much, but you know, you're not gonna rush to make that.
We don't hear that number.
Yes.
How many wells are they plugging at this point? I can't remember the last time you gave us an update of their.
I'm sorry, I don't know the answer. And this one is a Van Buren Energy
Right.
well. So, you know, those wells that they obtained from XTO, they're more in the beginning of that process, like they went through with the wells that Flywheel received from Southwestern Energy. But I'll make sure to have all of that information for the next hearing.
Is this on a workover list for them?
Yes, it is.
Any other questions from the commission? Conclude your presentation, Mr. Perkins?
It does.
All right, with that, anyone in the audience wish to speak to this? I didn't do that the last time. Now, for the record, there were none. I'll call the evidentiary record to a close. This matter is ready for adjudication. Motion from the commission. It's moved to approve. Is there a second? Commissioner Weiser has seconded. All in favor, show of hands. Motion passes. Thank you, Mr. Perkins.
Thank you, Judge.
Next item on the docket is, or on the agenda is docket number 05-2024-07. Applicant is Weiser Brown Operating Company. Mr. Daly is returning the record. Subject is establishment of field rules. The location is set forth in the application. County of Lafayette, Shiloh East. Mr. Weiser, I assume you're recusing on this matter. Any other recusals? Yes. Commissioner Weiser has recused as well as Chairman Langley. Daly, you are recognized, sir.
The applicant's documentary evidence is summarized and tabulated on its Exhibit I. We have two witnesses, Mr. Rodney May, a land witness, and Ken Fritchie, a geologist. Ken's credentials as an expert in petroleum geology were first recognized by the commission in its order reference number 68-85. We move the introduction of these exhibits into evidence, the recognition and incorporation by reference of Mr. Fritchie's credentials, and request that the witnesses be sworn.
This has been previously accepted as an expert. He is an expert in this docket. And your motion to move the exhibits into the record is granted.
Request that the witnesses be sworn.
please. Gentlemen, do you swear or affirm the testimony you're about to give in this hearing is the truth?
I do.
Thank you.
Bonnie, state your name.
Rodney May,
Did you, at my request, identify all of the owners of the right to drill and produce in any of the offsets to the initial unit, which is described, I'm not going to go over the legal description because it's complicated, which is described in the application?
that is correct, yes.
And have all the names and addresses of all of those persons whose identities and addresses you could determine been listed on Exhibit A?
Correct.
And the affidavit of mailing of such has been filed.
That's correct.
Any
yes.
questions for Mr. May?
Commissioners, any questions? Please proceed, Mr. Daly.
Ken, please state your name.
Ken Fritchie.
If you would, please, just explain the geology surrounding the initial 40-acre drilling unit, as well as the required configuration for any extensions to the unit as this play is somewhat expanded.
This, the double E well was drilled by Wiser Brown, was a discovery well.
This is the, sorry, I think this is.
Are we on shallow? Or are we on shallow? That's east or?
Am I on the wrong one? Well, my apologies. Unfortunately, Mr. May's testimony would be identical regardless. And I will open up the correct file. And Mr. Fritchie's credentials haven't changed. Go ahead. I'll catch up.
This is a seismic, 3D seismic prospect that was drilled on a down to the east fault in the Smackover, discovery in the Smackover. As you can see, it's a fairly narrow field along the fault, and we've asked for a 120 acre unit to cover basically the entirety of the field, mainly for convenience and to have all the royalty interest owners paid from the beginning. We would like to drill a second well that would be up higher on the structure down to the southwest, within that same unit, so that we could get the attic reserves that wouldn't come out of the first well, that double E that's on the section line there. We'd like to limit it to 60 barrels a day, but so that we wouldn't pull water in from the water contact, which is very near the well bore in the double E. So that's why we have that larger unit, just to cover the entire unit or the entire field.
Do you believe that this well plus the second well, which you anticipate drilling, will adequately and efficiently drain the hydrocarbon reserves within the whole unit?
Yes, with that second well, I think that would drain the field.
And if you tried to bust this up into two separate units in a field, would it deny you the opportunity to drill wells at ideal locations?
Yes, if it was, it would make it, you would over-drill it probably.
Questions for Mr. Fritchie?
Sure. In your application, Mr. Daly, under item 5, you request 100 barrel a day.
allowable. I think that was my thought at the time, and I think that's been changed, and we would move to amend the application in accordance with Mr. Fritchie's recommendation.
Thank you, Mr. Daly. Motion is granted. Application is amended. Any other questions from the commission? Anyone in the audience wish to speak to this matter? No, for the record, there was no response. Mr. Daly, do you rest?
We do.
Sir? With that, file the evidence part of the record to a close. Matter is ready for adjudication. Is there a motion from the commission? Commissioner Watson has made a motion to approve the application as amended. Is there a second? Thank you. Commissioner Phillips has seconded. All in favor, show of hands. Motion passes 6 votes. Thank you, Mr. Daly. And you are last up.
Yeah.
Oh, I really should have called. Docket number 046-2024-07. Applicant is Weiser Brown Operating Company. Mr. Daly is the attorney of record. Subject is establishment of field rules. Location is set forth in the application. County is Watchdog. Field is Langley East. Mr. Weiser, I know you were recusing from this matter. Chair Langley is recusing as well. And Commissioner Thomas has recused. Do we have enough votes?
You have exactly enough votes. We counted.
Exactly. We'll make certain. Mr. Daly, with those 3 recusals, you are recognized, sir.
Thank you. The applicant's documentary evidence is summarized and tabulated on its Exhibit I. There again, it lists the credentials of Mr. Ken Fritchie as an expert in petroleum geology who's first recognized as such in order reference number 68-85. We move the introduction of those exhibits into evidence, the incorporation by reference of Mr. Fritchie's credentials, and request that he and Mr. May be sworn.
Credentials as an expert are accepted. The motion to move the exhibits into the record is granted. And gentlemen, do you swear from the testimony about to give in this hearing is going to be the truth?
I do.
Thank you both. Mr. Taylor.
Rodney, please state your name.
Rodney May,
And how are you employed?
contract landman for Weiser Brown Operating Company.
And have you identified to the best of your ability all of the owners of the right to drill and produce in any of the 40-acre offsets surrounding the initial unit in this field, proposed field?
Yes, yes, sir.
And have they then been given notice?
Yes.
Questions for Mr. May?
Commissioners, any questions? There are none, Mr. Daly, please proceed.
Ken, please state your name.
Ken Fritchie,
How are you affaired?
independent.
Have you consulted with Weiser Brown in connection with the well and potential future wells that are the subject of this application?
Yes, yes, I have.
Please explain the geology of this well and explain the reason why it is, while it is 40 acres, those 40 acres do not represent a governmental quarter section, and how that plays out with your request for the extension language of the field rules with respect to offsets to the east and west.
That's one. So,
Okay, let's go ahead and hand that out. Mr. Fritchie is handing out, I think, a replacement exhibit C, which is identical to the previous exhibit C, except that it has sketched on it possible future wells in addition to the initial well.
Mr. Chairman, this exhibit 15 is part of the record as objection.
We move the map that Mr. Pritchett just handed to Mr. Moulton and each commissioner be admitted into evidence, and let's label it Exhibit J.
I'm sorry, exhibit what? J?
Yeah. So we have the initial Exhibit E, or excuse me, Exhibit C, which is a structure map, and then we have another Exhibit C, which has the initial unit and potential offset units sketched on.
The motion is granted. I guess just make certain that the court reporter gets a copy of all this and give her a roadmap of how to do it all. Mr. Daly, please proceed.
All right. Now, using Exhibit J, as well as Exhibit D, if you want to, which is the ISPAC map, explain the geology of the discovery well and the reason for the stair-step configuration of potential future unit well sets extensions.
Okay, this is a Buck Range discovery, right around 2,000 feet. It's a faulted structure down to the south fault with a north dipping structure closed against the fault. And it's was defined with 3D seismic. So we have feel good about the orientation of the fault and the structure. I feel like we have it pinned down pretty well. Therefore, the units, we've crossed the section line there because we would probably leave a gap in the north part of section 3, and this would follow as you go to the southeast, to the east. The units as shown on that handout, the 40-acre unit would drop down. I believe it's 5-acre block, and to cover the structure and the production on the north side of that fault with that unit. And then back to a normal governmental section or 40 on the west side. But the reason to stagger it is because of the fault and to not have to drill too many wells, over drill the field. It's because the well currently makes 10 barrels a day of water and 10 barrels of oil. So it's not real prolific. We have to limit the number of wells we drill in to be efficient.
Questions for Mr. Pritchett?
Commissioners, any questions? None? Mr. Daly, will conclude the presentation.
Yes, it does.
Thank you very much. Anyone in the audience wish to speak to this matter? We're done. Call the evidentiary part of the record will close. This matter is ready for adjudication. Is there a motion from the commission?
Who we approve?
Commissioner Wolford moved to approve as a second. Commissioner Watson has seconded. All in favor? Show of hands. So again, 1, 2, 3, 4. Commissioner Smith? Aye. 5 votes in favor. Thank you, Commissioner Smith. I would just try to. He's still forward. All right, we're gonna go ahead and go off the record for 15 minutes, and we will reconvene. 10:25, we are off the record.
Well, we're gonna pass my pop.
Yeah, me too.
Well, my wife texted me that the Secret Service director was her comment that that group was too spread.
And there's no way that you, now, you can't do that, because you have too many mics in it. You can only have one mic. Yeah. Well.
There's some out there, you know, it's crazy. Yeah.
Good to see you. And it went boom.
But the kid was like a carrot. It'd be like stuff was saying, okay, we'll be looking. And then they came like hours later. It was a mess. I've never seen anything.
They don't need to hear whether it's doing
Another man could just go away.
Well, I've had flat rates, but I've never had a deal with a fencing free.
That's why. I am the new. I'm trying to bring my first one. No, that's too small. When do you go right? Well, we're doing it at lunch on the trail. We can slow Yeah. What was the deal with the officers? Okay. Because I know that they did other pilots in operational training. Is that like what this is? That's just something different. Things that is not so. They aren't currently, are they currently using? That's what I thought. They have to get an order from you guys. So what they were basically just asking is when do you use? Yes. Yes.
That nice little man up there being charged.
So. So what's the difference between extended? Yeah. The difference between they get close to their production. And here's the thing is, we have they are fun to work with. No, they are. They're fun to work with, but they don't. Yeah, right. And they're so helpful. They want to do the right thing. To each other. Like,
Yeah.
so what I'm doing is they weren't.
That is an interesting spot.
Yeah.
They were just asking not to.
We'll make it
Useful. It's not quite like that when it's tree growing around. Yeah.
We had the one a while back that had a coat.
Oh, really?
Yeah, the whole, a couple months ago. That's all I had. I wanted to make sure you had the amended or the updated applications. I didn't mark them. I didn't know if you had that.
Yeah.
We're gonna be referencing exhibit C. I didn't mark it.
Nice to meet you
I forgot to put the exhibits there. I just hammered it in.
Thank you.
We're gonna refer to it.
Makes it easy. Just thought I'd introduce myself. Hi, it's nice to meet you. How are you? I'm good.
Yeah, that was a long time. Yeah.
The Secret Service director just resigned. That was a. I just saw. I don't know why she went through it. Still, I understand why they keep. Separate. We're supposed to be a Secret Service agent monitoring the radio.
We go several times a year, which you kind of have to do. You gotta have to be sure it's still there.
Right. And we're talking over. And see. There's a lot of media.
We were last there.
I mean, it's based.
They can fly from tonight. And we were there for about almost 3 weeks. I've got an office in the house. I don't come Fort Smith all that often.
And not in so they never over 2 hours. I've got the same. One doc I saw that that's a we were. Okay. Waiting on. What's that barbecue I would like to go to? Because you're conscious of that.
Probably half of it. 4 hours, like 3 or 4.
Okay. I'm ready. So you got from Dallas. Oh, yeah. Yeah. Yes. I'm not sure. Yeah,
Well, I guess it all worked out okay. Well, I'm just off. My wife was there. Anyway, they didn't, saw they didn't. Yeah, well. That's the way I was going. I have. And hard. Oh, yeah, yeah, I got those somewhere around here. Is that it right here? Yeah, I got it. All right, there you go. Yeah, Charlie. Really? You gave me my word. Did you get everything you need?
I think so, and I'm getting more stuff, so.
I just wanted to make sure you got everything.
Yeah.
Yeah.
And some of mine are still on the computer, so. Yeah. Anything goes.
Hey, Jerry. We're gonna go ahead and start.
Next director is right in the back.
All right, commissioners, we are back on the record. Mr. Daly is sitting at the table because he notified me during the break that in previous docket number 046-2024-07, they needed to do some sort of an amendment. Yeah, I'm not sure procedurally whether or not the commission needs to make a motion to reopen.
I think it's
that
actually
docket.
045.
Zero. Oh, is it 045 or 046? Yeah.
It's 045.
Mr. Daly?
I,
45.
yeah,
045.
045.
All right. Apologies. Thank you, Commissioner Wolford. All right, 045-2024-07. The Weiser Brown Operating Company, Mr. Daly, you're recognized, I guess, as a threshold matter, Commissioners. I don't know if you need to make a motion to reopen this docket or whether or not we can just do an amendment. What's the procedure? All right. I was told that I can make the rulings, Mr. Daly. So with that, you are recognized, sir.
Thank you. I'd like to call again Mr. Fritchie, who is still under oath. Ken, with respect to the allowable request for the Shiloh East field, you testified that the current well would make 60 barrels a day.
Yes.
Is it possible, and in fact, hopeful, do you hope that the second well will actually perform a little bit better than that?
Yes, and it would be further up dip, and the reason I brought up 60 barrels a day was that Weiser Brown wanted to limit that well to 60 barrels a day because it's so close to the water level and it might pull in water. But the second well should be up much higher and further away from the oil water contact. Therefore, the allowable, which was in the application of 100 barrels a day, was what we were asking for.
So in essence, what we are requesting is that we remove the amendment that was previously erroneously made. And I think that the commissioners probably would need to vote again.
All right, so you are moving to remove the amendment.
Yes, sir.
All right, that motion is granted. Commissioners, any questions that you would like to ask? I do see one procedural hiccup. Commissioner Smith isn't on the Zoom call anymore. I think in docket number 045, however, we just had Commissioner Weiser and Chair Lane.
You have 5 present in the room.
We still have 5 present.
The original motion was Lawson and then Phillips was the second.
I believe that's correct.
There was only 2 refusals on that.
Just 2 recusals.
Yeah, no, I'm just talking about who made the motion.
Commissioners, do you wish to move we approve? Commissioner Lawson moves to approve. Is there a second? Commissioner Phillips, all in favor, show of hands. Motion passes by 5 votes.
Yeah.
Next item on the agenda, docket number 039A-2024-07. Operators Crawford Production Company. Continues the attorney of record. Subject is in order to compel compliance and request for civil penalties. Based on the operator, any recusals from the commission? For the record, there are none. You are recognized, sir.
Thank you. The pre-filed exhibits I would move for admission include Exhibit A, the Commission Form 1 organization report, the notice of violation that has been filed, the affidavit of notice, copy of notice of hearing, and the proof of public notice from the Arkansas Democrat Gazette. I would move for admission of each of these pre-filed exhibits into the record.
Motion is granted. Those exhibits are made part of the record. Commissioners, I do not know whether or not you have any recusals on this beyond what we've already gone through, but go ahead and recognize. I will also note for the record that Commissioner Smith and Commissioner Weiser are no longer present in the commission room. Please proceed.
Thank you. This is a request for an order to compel Crawford Production Company Incorporated to comply with General Rule B2, where they have not paid the annual well plugging fund or assessment fee. We are requesting a penalty in the amount of $1,000. That is based on a previous history of non-compliance with this rule. We're asking you to compel this operator to pay the fee and ask for that amount to be assessed at this time. Nothing further.
Thank you, Mr. Copeland. Any questions from the commission?
Yes, who's the principal person of this?
Who's one of the members, I guess?
Yeah.
I believe that may be reflected on the Form 1 and Exhibit A. I'm not sure if I can even, Chris, I think it says Barker. I can't kind of really read their handwriting very well, but in the Exhibit A for the Form 1 that we have, there's Chris Barker, Donna Barker are listed as members and operators of the entity itself. I think there is some officers listed on the second page of Exhibit A, Shirley Crawford, Don Crawford, and Donna Barker. I believe there's also an email exchange that they had with staff on some of this as well with Chris Barker.
So Don or
I believe it was Donna.
Don? Not Don.
No, Donna. Looks like a female name.
Okay.
Listed as a president on a previous Secretary of State filing.
All right, any other questions from the commission? Does that conclude your presentation?
It does.
Based on Mr. Pinkleton's presentation and some of the questions that I heard from the commission or inquiries, are there any abstentions at this point? No, for the record, there were none. Call this matter, the evidentiary records were closed. This matter is ready for adjudication. Is there a motion from the commission? Motion. Chairman Langer has made a motion to approve. Is there a second? Second. I'm going to skip over you, Commissioner Wilford, and note Commissioner Westfall has seconded. All in favor, show of hands. 6 votes in favor, motion passes. Next item on the agenda, docket number 0448-2024-07. Ken Arc Oil Company, Mr. Pinkleton is the record subject of request for well abandonment. Location is southeast quarter, northeast quarter, section 22, township 17, south range 16 west in Union County. Field. Are there any recusals from the commission on this matter? No, for the record, there were none. Also know for the record that Commissioner Weiser and Commissioner Smith are no longer present for this. You are recognized, sir.
Thank you. Pre-filed exhibits I would refer to at this time. Exhibit A is the Commission Form 1 organizational report. Exhibit B is the commission plugging record regarding this well. Exhibit C are some well site photos that were taken by commission staff. Exhibit D is the notice of hearing regarding this matter. Exhibit E is the affidavit of notice, and Exhibit F is the proof of public notice published in the Arkansas Democrat Gazette. Commission staff would move for admission of each of these exhibits into the record at this time.
Motion is granted. The exhibits are part of the record.
This time I would ask for testimony from Mr. Looney.
Or would you be so kind? You swear affirm the testimony about the giving this hearing is going to be the truth.
I do.
Thank you, sir. Please proceed.
Mr. Looney, you are employed here with the commission. You're very well aware of what's going on down here in South Arkansas for the most part with operations. I think that's fair to say. I would ask you at this time, why is commission staff requesting that this application be granted?
Yes, this was brought to our attention from a landowner through a request. This used to be a pond area. It's been drained at the moment. It revealed that a well, former Movie E #1 is present. It's actually is working as a support to the fishing pier. The fishing pier is welded to top of surface casing here. It was plugged, but evidently not cut and capped at the surface. We're a little bit concerned of the proper plugging of this well, given the nature of and the time frame it was plugged. If we do need to go back in and set any type of plug, especially over fresh water, we need a permission from an authority to expend funds from our AOW well program through a commission order. So first off, we get the commission order, then we'll see about tackling the well issue here.
Can you tell us a little bit about the history of the operator, or if there is any history with this operator?
Well, I have some limited knowledge of them. They operated in South Arkansas, and they drilled wells and operated wells in South Arkansas, but they've also been not here for many, many years as an operating company, and I honestly don't know if they even exist anymore.
It is a commission staff's position that it's necessary to expend the fund at this point to protect the public from any hazards associated with this well, to make sure it's full.
Yes.
Okay. I have no further questions at this time.
Thank you. Commissioners, any questions?
Gary, you gonna have, so you just gonna crawl on there and cut it off, and put a plate on it? Are you gonna tear the shed down? Or?
Right now, the thought is to more or less put some outriggers to that casing and stabilize that casing, and yes, cut and lift that dock off of it. Because if we do re-enter it, that casing sure needs to stay as straight as possible. So I want it to stay that way while it's cut and removed, or the pier's cut off and removed from it and everything. It's only surface pipe here. Yes, and very little of it, according to the record, maybe only be 16 feet there.
Was it underground and then they exposed it when they took the pond?
I don't know. This was actually done by the previous landowner out there. In the conversations with the current landowner, they more or less bought it. This is the way it was when they acquired it.
And just the grade, it looked like it high back toward that house. I thought maybe they bumped into it, while they was digging the pond out.
That would be my thought.
How did they drain it why did they drain it,
The landowner stated he didn't currently want that pond any longer. He has a much larger one nearby. Don't know his full plans, but at the moment he's not wanting that pond.
Did it ever have a long string in it?
Our records do not indicate that.
Thank you, Gary.
It just had a fishing string in
So you think that's just surface pipe?
Yes, sir.
And 16 feet of pipe is all
That's the record, but in the well, it was plugged with only 5 sacks at 1,200 feet.
it. See, the dock was stabilizing it and holding it down.
So
how deep was the well, Greg?
total depth was 2,198.
So they didn't cut the grades, they just cut the spike of
Naked out there.
Yes. That's close.
Any other questions from the commission? Okay, rest.
I have one more follow-up question for Mr. Looney. I believe that you indicated there's been some discussion with the current landowner, is that correct?
Correct.
Has there been any opposition to any activities that commission may commence to plug this well?
No.
Nothing further.
Try to do it before the winter sets in.
Would like to. Yes.
Any other questions for the commission? Now do you rest, sir.
Yes, sir.
All right. Anyone in the audience wish to speak to this matter? That's the record. There is no response. Call the evidentiary part of the record to a close. Matter is ready for adjudication. Is there a motion from the commission on this matter?
Yes.
Commissioner Langley has made a motion to approve. Commissioner Lawson has seconded. All in favor, show of hands. 6 votes in favor, motion passes. Thank you, gentlemen. Next item on the agenda is the open docket. Typically, I get a lovely list of questions that I ask the audience, but that's missing today. So I will just ask for the public comment section. Does anyone wish to comment on any matter within the Oil and Gas Commission's jurisdiction? None. Turn it over to you.
Thank you. I'd like to recognize the visitor today. Secretary Curry has graced us with his presence here.
I'm respond, I'm speechless. Yeah, I'd say I kind of had a.
I want to know if that means we're supposed to call you your grace.
I'm just still trying to figure out where I'm supposed to sit. Going to somebody else's house that now lives in your home, you know where to sit.
You want to introduce at least one new staff member you have here with for E&E?
I think we probably have a few we need to introduce. So I think most of you have met Lauren Ballard before. Lauren was our chief counsel and has moved into the chief of staff role. She's been doing that for not quite a year now, but I don't know if you officially recognize that. We also have Tisha Morrison, who is now our new chief counsel. Yesterday was her first day, so what better thing to do than come see Oil and Gas Commission. She's come to us from the Attorney General's office. She's been in the civil litigation department there for 5 or 6 years, give or take. Also has some experience in legal aid in other places. So we're happy to have her starting here at the department. And met Rachel this morning from the governor's office. Who else do we have that I haven't introduced?
Julia is now
Well, Julia has
attorney.
changed positions because she worked the Oil and Gas Commission for years going through, when she was going through law school. She has now passed the bar. Julia Rainey is an attorney now with the department. So she's moved up and helping Dan a lot on the energy side, specifically the oil and gas side. Like a lot of royalty owner complaints and the hearing process and several other things on kind of the energy side of the department. So we're happy to have all that here. I think everybody else y'all know, off-state geologist staff and communication staff. So Keisha's our newest person, kind of like Wes said, 1 day old, second day on the job, so she's learning.
Gary was Lacey introduced at our last hearing.
I don't think so, don't believe it.
Okay, why don't you go ahead and introduce Lacey, new staff member down here.
At the far left of the table, right for some of you, is Lacey Campbell. She has come to us and is working with and under Rex right now, learning all about our permitting and how our files work, how you dig through files. And she's been having a great time digging through files lately on some projects and everything, doing a very good job of it too. So we're well pleased and happy to have her here.
So if you have permitting issues and you're used to seeing Rex's name in the future, you probably see Lacey's name in the future too. So that's who new staff are. Okay, what we have to do is we have 2 rules that I've sent out to you dealing with an issue that we started working on some time ago. but it's general H1 and B2. As you recall, I think a couple of years ago, we transferred the regulatory authority for SWD wells from DEQ to the service facilities, from DEQ to the Oil and Gas Commission. We did not transfer the commercial disposal well surface facilities, and we did not transfer the surface facility associated with 1,000 barrels of storage and larger from DEQ. That remained under DEQ's jurisdiction under their Reg 1. We completed the rules to make that transfer complete for commercial disposal SWD wells, surface facilities to Oil and Gas Commission, as well as those larger storage tank facilities over to Oil and Gas Commission. And so these rules primarily address that. They do address other issues that I'll go over, but the general rule H1 specifically deals with the transfer of those SWD surface facilities from DEQ to OGC. And all the red language that you see essentially deals with that transfer. There's just small amounts of language through the rule specifying that those facilities are now under AOGC. One particular thing that we did do in addition to the SWD, when you look at page 2, definition of number 9, we included a constituent contained in brine as part of a, so things that may be in the brine, which may be hydrocarbons or carbon dioxide, or hydrogen sulfide, or other constituents contained in the brine. If they're all part of the brine, that's approved as spent brine for re-injection. Any questions on those amendments to make that transfer of those facilities from DEQ to Oil and Gas? Rich? We'll need a vote. They've been through the governor's office, so we just need a vote to start the rulemaking process. We haven't done rules in a while. I know. I'm out of practice here. We have a motion to approve. We need a second.
Second.
Motion to approve and second. All those in favor?
Can I vote?
Can you vote?
I got one of them. Vote.
Why can't you vote?
Well, I got one of them supplements.
Well, these are rules. You can vote.
Okay.
Gotta give them right. Okay. Approve the parking rulemaking process for H1. Rule B2 deals with the same issue, but it also deals with some clarifications we had to do and some other bonding issues that we had to address for future rules coming along and activity that's now occurring. So I'll go through all those as we go through it. Start with item or section C. We need to clarify because as new operators come into the state, they're not familiar with our procedures. We need a clarification of when a bond is required. So we clarified when that bond is required and how long the bond stays in effect. And that's what C does. So it stays in effect until the well is transferred or the well's been plugged. And see that evidence that operators have been here for a long time. And we need to clarify that for new operators as they come into the state. D, we had to clarify also how long does that bond remain in effect? what you have to do to get it released once you plug the well or transfer the well. Again, these are clarifications that you are familiar with as active operators now. With new operators in the state, we need to clarify that. We also need to clarify on page 2, a new C. We had an issue developed, we're currently potentially in litigation over, where a letter of credit was not honored by a bank. So we had to change some language on our letter of credit going forward. So C simply allowed that for me to change the language on that letter of credit to ensure that there are no loopholes for a bank not to honor that letter of credit. G on page 3 deals with the petition and amendments to the bonding requirements for various issues. And some clarifications again. Number 1, reestablishes what our current bonding is. Just some clarification of when, how many wells are the blanket bond, individual well bond. There's no change here at all. We just rearranged some sections under G1. It says the same thing as it did before. We just clarified it. G2 is actually a new provision. Up until this time, we have been treating brine supply wells and brine injection wells similar to oil and gas wells. They're much different, especially in the plugging requirements. And so G2 establishes a new blanket bond insurance for brine production supply wells going forward, given we're going to have a lot more activity in the Smackover for lithium than we have before, which is 2 companies in the brine industry producing bromine. That establishes a new requirement for that. Currently, right now, Lanxess exceeds 2C and $1 million bond because they transferred from Great Lakes to Lanxess, and during that transfer process, we use the director's additional bonding requirements because of new operators and things like that. Number 3 deals with the commercial disposal well facilities. Even though they were permitted by DEQ, they were not bonded. We have at least, I think, 2 fairly large commercial disposal facilities here in South Arkansas with substantial reclamation required to be done. The wells have been plugged, but there's no financial assurances on file to clean up the surface facility sites. So this is the bonding requirements at commercial disposal wells, as well as large storage tank disposal facilities. Will have to post depending on the size of their facility and on the nature of their storage, to ensure that should they abandon those sites, if there's enough money to clean the surface facilities up, not just the bunker well. Our current bonding for just the well would not cover surface facilities. And then lastly, number 5 is basically a restatement of repeal H, just moving it around for the director to establish bonding for various conditions related to the facility that may potentially go above the bonding in the rule. So those are the changes. It covers more than just the SWD issue, but since the other rules, especially the brine rule, coming along later this year, I didn't want to have to reopen the rule 2 or 3 times. Keep adding pieces to it. So, any questions, discussions on that? Have a question?
I got choked up.
Okay. Okay. Have a motion to approve the rulemaking process.
I do.
Second. All in favor? Unanimous for those who are here. We'll move forward with the rulemaking process. That's all I have. Oh, Gary, you want to give an update on our plugging federal part, our federal project?
Okay, we've just reactivated the rig. We've been in sort of maintenance mode, fighting off wet weather through the winter, and the beavers and beaver dams, nuisance animal control, we continue to work, run traps, and blow dams. Finally got dry enough, we started road construction and building more pads and such, working with a few landowners on a specific issue. And looks like we're going to build a bridge, looks like we're going to tear down a house. So some new adventures for us. But we did get a rig back our way at the beginning of last week. And so we plugged about 4 additional wells. We're about at 61 or 62 wells plugged in the project. With Greg's and Lacey's help, we continue to scrub data, and our start with 227 wells. We're 225 or 4 now, I think. Taking a few out, adding a few back in as we go through the data. But till the yesterday day's rain, it started to dry out pretty nicely, and we were moving forward. We'll see what this does and how long the rain lasts. But in any event, we hope to have a rig for about 60 days. Start up and plugging wells. But, working with the mayor in town as we move in town, because we do have a well that is directly behind the house, and the house roof is 2/3 falling in. Have an ordinance to smash it and get rid of it. So we're going to partner with the city, help them smash and get rid of it and everything. So we can get in and plug the well. Got to build a bridge with 1 fill in to get to a few stranded wells fast. Achieve that this summer. If it continues to thrive, hopefully it will. Places established.
I also think, Dan, correct me, next week or the week after, we're going to start flying the area with our UAV equipment, magnetometers, ground penetrating radar.
Yeah, we're gonna come down. Gary's probably gonna look at me like, what? I didn't know that. I don't know if he knows or not. They're coming down.
We're coming down in a week, Gary.
We just went through the training with the supplier, actually the overseas. The pilots went through a training on the magnetometer and the ground penetrating radar to learn not only how to use it, but how to interpret that raw data that comes back. They've learned a lot. So I decided, I guess, for them to come down, spend a week without having to go back and forth and wasting 4 hours a day going back and forth. Come down, stay, fly a bunch of surveys, see what we can figure out from that. So this is the learning curve. And this was always the challenge to me on the UAV, was how to do the surveys that actually give us useful data. And then how do we interpret that data that's returned? So that's what we're going to do in the next couple of weeks. Hopefully we get good results. We can start looking at how to identify. I'll go ahead and say We found out through training, as we already knew, the lower we can be, the better we're gonna be. If we're gonna fly these instruments at 200 feet in the air to get over all the pine trees, it's not gonna tell us a thing. We've got to get down low to be able to make it. So it's a challenge, but we're gonna see what we can do and the results. And hopefully in a month or two, we really have some good results that we can say, this is how this equipment works and how we can use it. I say all that to say this, you know, we may be flying different areas of the state, especially after I see a cutover, and I know everything's low, I can fly those instruments as low as we possibly can to get a better return. So that's what we're doing in the next 2 weeks, and sort of a blind test to see what we can find, and maybe tell Gary, this is what we found, and he can say, oh, I didn't know that was there, or he could say, yes, you're right, it is right. So that's our goal.
We also invested in upgrading our aircraft so that it has a capability to stay at the same elevation, no matter what the ground elevation is. So the pilot doesn't have to move it up and down, move itself up and down to follow the slope of the land, I guess.
It has a laser altimeter that what it
Stay at the 10 or 15 or 20 feet. The purpose of all that is of 225 or so wells we have, there's about 30 or 40 we have not found yet or located, because a lot of the area is just in a swamp. So hopefully this will help us locate some of those sites just not visible physically now.
Terry, is there a way we could just have a simple spreadsheet every month just showing what we got done and what we expended and how much we got left?
Actually, we do that now for DOE. How often do we report to DOE? Once every quarter?
Yeah, just whenever, if we could just have a.
Yeah.
Just kind of keep track.
We do that already.
You're one of the classics in my career, Van Buren, Arkansas, landowner wanted the house gone. We had 3 dozer operators that wanted to drive the dozer through, and only one could do it. And it's a classic video. If you might get the governor down. Just,
It has occurred to me.
First swing. Yeah. Thank you.
Okay, any other questions? Issues? That's all that I have.
This meeting's adjourned. Thank you.
$11:30. 11:30 is lunch. Hang around.
I'm gonna get hot.
Was there ever a